So far, we've looked at what law is, and then we've also tried to distinguish the common law system from other legal systems. As part of that, we looked at how law is structured within the common law systems and some of the most important rules that might affect how you think about law when you're in business. What we're going to do now is extend this and start thinking about the Australian legal system in particular. To do that, we've got to look at some of the hallmarks of our system, some of the principles on which it's based and why they're based on these principles, and their historical development as well. That way we'll have a much more nuanced and better understanding of our legal system and how it all fits together. That will allow us to do the last segment, which is how the system actually operates today. So, one of the most important things to recognise about the Australian legal system is that we're based on a federation. Not all governments are based on a federation. And why is that important? Well, there are actually two governments for every citizen of Australia. Essentially, you've got your state or territory government, and then you've got the federal government, or the one you might normally think of as the Australian government. But both of these governments have the power to make law, administer the law, and apply the law. So it really is critical to your understanding that you recognise the federated nature of the Australian legal system. Now, we could do an entire course, probably an entire degree on the Australian legal system. We don't have time, so we're going to concentrate on 6 key ideas or principles that underpin our system. Let's go through them in detail. The first thing to recognise is that Australia is a liberal democracy. What does that mean? A representative democracy where we vote for the government. So our laws are made by and administered by elected representatives. They exercise their power subject to the rule of law. You'll remember that from an earlier video. So the law is supreme. The people running our government have to do it according to the rules, to the law. That's what that means. They don't get a special right to do whatever they want. And what they can do depends upon which government they're in, the federal or state government, and the constitutional powers those governments have, something we'll come back to later. Okay, the second principle, I think we've been over a couple of times already. Our legal system is based on, has its heritage in the British legal system, and is a common law system that has judge-made law as part of it. The third key thing to recognise is that we are a constitutional monarchy. Oh my goodness, what does that mean? Well, the head of state of Australia and the states is the King at the moment, the King of Australia. That sounds really odd, doesn't it? But they actually are the King of Australia. And they're not our head of state as the King of England. That was changed in 1986. So we have the King of Australia is the head of state. But they don't actually do anything. They're represented by a couple of roles we have in our government. At the federal level, the Governor-General, and at the state level, the governors. They are the representatives of the monarch. But even these representatives have to act according to the rule of law, right? And the law that says what they're allowed to do is in our constitution. So that's why we're a constitutional monarchy. The fourth key thing that we need to recognise is that we're a federation. So Australia was not initially set up as a single country of Australia. What it actually was a series of independent areas, the colonies of the time, and they all came together and agreed to become a country. They federated. So what technically happened is an area like Queensland, the government here had all of the power, and then it gave up some powers to the federal government. That's super important to understand, right? Because the federal government can't do whatever it wants. It can only do what the states gave up. So federation is a core concept to understand. The fifth principle underpinning our government is that of separation of powers. I'm going to pause because we've got a few slides on the separation of powers and what it means. But in essence, those who make the law should not be the same people as those who administer the law, and they should not be the same as those who judge, right, the law. We should have a separation between these three powers. That's important so you don't end up with an individual or group having absolute power. If you had one person who could do all of these things, then they could make whatever law they want, they could administer it however they wanted. And even if they didn't, even if they wrote the law wrong and someone said, well, you can't do what you're doing to me, they would just judge it the way that they wanted or remake the law, right? So we don't want one person to have absolute power, and one of the ways we stop that is through the separation of powers. And it could be one person, or probably more likely we don't want one group to have absolute power. The final principle that you should be aware of is intimately tied to the Westminster system of government. Again, it has UK heritage. Under the Westminster system, we have the principle of responsible government. What does that mean? It means that the executive branch of government are actually headed by elected representatives. So what's the idea here? The idea here is that the person in charge running the operations of government should have to report back to the people through Parliament. And we do that by making sure those who are in charge of each department or each area of the operations of government are elected. So ultimately, the head of the executive are answerable to the citizens. Now, if you're paying attention at home, what you'll recognise is this creates a bit of a problem, right? Because the separation of powers says that these should be separate, that those who make the law, parliament or legislation, should be different from those who administer the law or put it into practice in everyday life. That's the separation of powers. But we've just said in responsible government, the people running the government, the day-to-day operations, are actually elected. They're part of the legislature. So yes, under the Westminster system, there is not a strict separation of powers there. However, what it does mean is that those heads of the government, those heads of the departments running the day-to-day operations, have to report back to Parliament. So they're accountable back to the citizenry. It's a very different situation from a country like the US, for instance, where the executive is elected entirely independent of the legislature. They elect the president who appoints the head of each of their departments. So there was a lot of confusion, I think, around that most recently with the latest US President Trump, which we might get into when we look at separation of powers. But these are the hallmarks of the Australian system. We're a liberal democracy, we have a common law system, we are a federation. We try and abide by the separation of powers, particularly a strict separation between the judiciary and the other branches of government. We don't have a strict separation between the executive and the legislature because of the principle of responsible government. And then finally, our system is a constitutional monarchy. So just as it's useful to understand how the common law system evolved, I think it's also useful to understand historically how the Australian legal system evolved and how we got to where we are. So, of course, any brief summary is going to not do justice to what actually has occurred, the complexity of what's occurred, and just give you a kind of main brushstrokes of the historical development of Australia's legal system. And that's what this is meant to do. Not go into the nuance, some of the areas where there's a controversy and no clear, totally agreed opinion, but rather the aim is to give you the overarching theme of how things evolved. Okay, so if we go back in history, we have First Nations are in Australia with a complex system of tribal laws and customs. Then the British send out Arthur Phillip and establish a colony of New South Wales. So two things occur. One, I think we need to recognise that this is a penal colony. This is a large jail. That's what's established here. And at the time, the British didn't understand fully the systems of laws in place, and therefore they didn't recognise any of these legal systems. So we actually are founded in Australia under martial law, under military law, because it's a prison. And at the time, the British didn't perceive any of the laws in place as being applicable to an organised society. So over the next 35 years, the colony starts to develop. And England, right, this is still a colony, so we're still English at this point, start to say, let's give some self-government. And they implement the New South Wales Act of 1823. Notice again, it's only in a specific region of Australia in place. This gets extended into a series of courts that are provided. So what we're really starting to see is a transfer from military law to civil society in Australia, still very clearly being part of the British Empire. Over time, other colonies are formed and they separate from New South Wales. And they start to have their own courts and their own system of government. So what we're now starting to see is a series of governments evolving in Australia. And in the late 1800s, there becomes this movement for these colonies, these areas of partial self-government, to come together for their common benefit. And that's what happens in 1901. These colonies federate to form the Commonwealth. So to think about what actually happens, we have these states which all have all the power, other than the British. The British government obviously retains the ultimate power, but they're governing themselves and they give up some powers to the Australian federal government, and they retain some powers. So that means the federal government can't make any rule it wants to. It can only make rules for those things that it has been given the power to make rules for. And the state government makes the rules for everything else. This dynamic means that we actually have two separate lawmaking authorities. We have the federal government and the state government. Both make laws. These laws apply to all the citizens. Now, this probably isn't written correctly. If there's any conflict, Commonwealth law overrides state law. That's not actually correct. A valid Commonwealth law will override a state law, and we'll get to why that's the case. But this won't be the case if the federal government is not allowed to make a law in a certain area. So that gives us the foundation of the legal system that we have, but I think it's important to recognise two other landmark incidents that occurred in our system. First one is the finalisation of our legal independence. So in 1986, the UK and the Australian parliaments passed the Australia Act, which legally separates us totally from the UK. So it ended UK Parliament's power to legislate for us. It removed UK courts from our judicial system. It made sure that the governors act on the advice of state premiers, not the UK. So it really reinforced and made sure that Australia's status is very separate to the UK. And for instance, that's why it's the King of Australia, not the King of England, who is our head of state. So this was a critical point where we can say very clearly we have a separate sovereign nation after this long period of evolution. The final thing I think to recognise, for two important reasons, I think it's important to understand it first, but second, to understand how our legal system works, right? So what we can see is that way back here at the beginning, the court system and the powers in place did not recognise the customary tribal laws that were in place at the time. This was super important because the British had a principle that whenever they brought a new law in, the old laws that were in place remained in place unless they conflicted with new laws that were specifically put in place. So it's not like the British would come in and their law would totally supplant all the existing laws that were in a society. They would only replace the ones where there was conflict. But the mistake that was made here early in our legal system was that they believed that there were no laws, right? And that was clearly not correct. That was finally addressed by the High Court around the issue of land rights, where our highest court said, hey, all back through history, our legal system has got this wrong. And so our judges, this is what's fascinating, the judges made the change to the law. And the law said, okay, if Indigenous rights to land have not been extinguished by some other law, another law could be that the local government allows it to be sold to someone. Okay, that extinguishes the native title. But if that native title hasn't been extinguished, then it's still held by those peoples. Right? So what we can see is the law can act to change where mistakes have been made, problems emerge, etc. Now, I think you could very clearly argue that it took far too long to evolve, but in the end, we see that flexibility coming into the system. So the land rights of Indigenous people are those that have always existed, and then we layer on top of it the laws coming from the Australian legal heritage, right? So that's what's really occurring, and where the Australian legal heritage has not extinguished those rights still exist. Okay, again, that's a lot of content to get through, but hopefully you get an understanding, particularly that idea of federation, how our legal system is constantly evolving, and you're starting to get a glimpse of the common law system, how the judges can clarify and adapt the law to changing circumstances and a changing understanding of what society expects and understands to be the case. The next video is going to get far more practical and look at our legal system and specifically how it operates through the three arms of government.